Hello, everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Associate Director of Practice Groups at the Federalist Society. Today, we're excited to host this webinar on FCPA and the Trump administration, what to expect from an America First approach to enforcement of foreign bribery laws. Our panelists today are Fry Warnick and Brian Rabbit. Brian is a partner at Vinson & Elkins in the government investigations and white-collar practice in the firm's DC and Dallas offices. Brian is a partner at Jones Day, where he is a litigator with extensive experience handling complex investigations, enforcement matters, civil litigation, and appellate matters. After our panel gives their presentation, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Fry, thank you so much for joining us, and the floor is yours.
Great, thank you, Caroline. Appreciate that. And thanks to the Federalist Society for giving us the opportunity to talk today. So as Caroline mentioned, a quick introduction. My name is Fry Warnick. I'm a partner in the Government Investigations and White Collar Defense Group at Vinson & Elkins. At the firm, I conduct internal investigations, defend against investigations by the Department of Justice, SEC, Congress, other federal agencies. After about 17 years in DC, I actually moved back to Texas where I grew up, and now I split time between both our DC and Dallas offices. I've been with V&E for about 6 years, and prior to joining the firm, I spent 11 years as a federal prosecutor in DC. First with the U.S. Attorney's Office in DC, handling guns, drugs, terrorism, Gitmo cases, domestic corruption and fraud, and then moved on to DOJ's criminal fraud section, where I spent the last 5 years leading and then supervising the FCPA unit, which focused on international corruption and money laundering cases. Also did a couple of stints at the Senate, one with Permanent Subcommittee on Investigations and another as a DOJ detailee to the Senate Judiciary Committee. So I'm excited to talk with everybody today about the FCPA. Hand it over to Brian, do a quick intro.
Thanks very much, Fry. And thank you as well to Caroline and the Federalist Society for hosting us today. Excited to talk about the FCPA and the second Trump administration's kind of evolving and developing approach to white-collar criminal enforcement. As Caroline mentioned, I'm a partner in the DC office of Jones Day, where I've been for about 4 or 5 years now, since the end of the first Trump administration. My practice is very similar to Fry's. I focus on all sorts of government-facing investigations, including DOJ, SEC, CFTC, Congress, kind of a whole host of government agencies, as well as internal investigations as well. Before coming to Jones Day, I spent 4 years in government, first at the White House counsel's office, working on congressional oversight and investigations and financial services policy. I then moved over to the SEC, where I spent some time in the enforcement division, and then advising the chairman on enforcement and policy issues. And then for the last 2 years of the administration, I was at the Department of Justice, first as the Chief of Staff to the Attorney General, and after that, as the acting Assistant Attorney General for the Criminal Division for about the last year of the administration. And after that, as I mentioned, I joined Jones Day. So again, very excited to be here, and we have a lot to talk about. So, Fry, I'll turn it back over to you to say some initial remarks about the FCPA and some of the issues that we're going to talk about today.
Yeah, great. So I'm going to open. I think most people joining probably have some familiarity with the Foreign Corrupt Practices Act, the FCPA, but just give a quick overview and really get us to where we are today with the law and how it's enforced. As background, the FCPA was passed in 1977 in the aftermath of Watergate, and it was the world's first law prohibiting foreign bribery. It occurred in the Watergate hearings, a discovery that a number of companies, publicly traded companies, had corporate slush funds, and that those funds are being used to pay bribes to foreign officials. It wasn't illegal at the time, but Congress acted and actually passed the law, and it's been amended a few times since. The law has always focused on the supply side of bribery, the bribe paying, as opposed to the corrupt officials with their hands out. And this is important, I think, as we talk through the approaches that the administration, could take moving forward. There are two primary provisions, both the anti-bribery provisions, prohibiting payment of anything of value to an official, and officials defined quite broadly, and also the accounting provisions. So books and records and the internal controls provisions, essentially making sure that the books and records accurately describe transactions and that there are appropriate controls in place so that people will know where their money is being spent, especially as it relates to issuers and publicly traded companies. And on that note, the law applies to companies and individuals, so long as you are an issuer, a domestic concern, basically a U.S. company, or there's catch-all provision for conduct that occurs in the United States. And if you are an issuer, if you're one of these member companies or an employee or a director, shareholder, et cetera, actually is quite broad in its reach. Now, for the first 30 years or so, the FCPA was hardly enforced at all. I think DOJ and the SEC, both of whom, SEC has specific enforcement authority over issuers, and DOJ can also bring cases against domestic concerns and for other conduct that does not involve a publicly traded company, for example. But DOJ and the SEC rarely acted. In the first 30 or so years, there were about 200 cases total, and the total amount of fines were about $50 million. The biggest one being a 2007 case for $21 million. And at the time, that was this landmark moment. Compare that to the last 10 years, 10, 15 years, you've seen a dramatic spike in FCPA enforcement. You've seen basically close to $30 billion compared to that 50 million the first 30 years, close to $30 billion now in global fines, corporate fines. And we've seen this occur at a time when DOJ has committed more and more resources. When I was in the unit, began in 2014, we had 14 full-time federal prosecutors working these international corruption cases. By the time I had left, there were over 35. Now, or at least coming into the new administration, there were over 40 prosecutors solely dedicated to the FCPA. On top of that, were dozens of lawyers at the SEC all over the country who also worked FCPA cases. And of course, AUSAs within each of the 93 U.S. attorneys' offices, some of whom handled these cases in coordination as well. On top of that, when I joined the unit, there were 0 FBI units dedicated to this. But by the time I had left, and more recently, there were 4 full-time dedicated FBI international corruption units solely working FCPA and money laundering cases like this. All of which is to say, this law, the FCPA, had become one of the most important, if not the most important laws used by federal prosecutors and the SEC to prosecute corporate crimes and regulate companies abroad. It's also, of course, become hugely important to the white-collar defense bar. A number of people have made great careers working these cases. They're lengthy, they're time-consuming, they're expensive. And, to be fair, they're actually a lot of fun to investigate. You're dealing with really interesting conduct halfway around the world. And so a lot of lawyers really were leaning into that kind of practice. I say all this to provide some context because obviously with the recent election, things have apparently are changing. You have the first kind of salvo was the Attorney General Pam Bondi put out a memo on February 5th, and she essentially dictated that moving forward in the FCPA realm, FCPA cases would be prioritized if they relate to cartels and transnational criminal organizations. So without that nexus, DOJ was going to be taking a much closer and more skeptical view of whether those are the kind of FCPA cases they were going to be bringing forward. And then 5 days later, President Trump issued his executive order on the FCPA, in which he initiated a 180-day pause on all FCPA enforcement, directed Attorney General Bondi to revisit all of the ongoing investigations and resolutions that were in progress, and also to develop new guidelines, to develop how the FCPA could be part of a more strategic America First foreign policy. It's evident, and as we've seen in the last 4 months, that President Trump is moving forward with his campaign promises to fight immigration, focus on fentanyl, drug trafficking, really focused on border enforcement, terrorism, cartels, human trafficking, and obviously, the FCPA was not at the top of that list. And so we now find ourselves in the midst of this 180-day pause. And one of the things that kind of spurred the decision by Brian and me to come and speak today was what does this mean for white collar enforcement generally and FCPA enforcement specifically? And particularly, there was a good deal of hysteria in the white collar bar and among anti-corruption activists saying that this is the death of the FCPA. The law is no longer in effect. Former Attorney General Eric Holder at one point made a comment, I guess it's now legal to bribe, which I would argue these reactions were overblown. This was not at all what was happening here, but instead, what we're simply seeing is a natural right sizing of FCPA enforcement within an overall context of criminal law enforcement. If you went around the streets and cities around any of the cities you may be in today and ask people on the street, what laws do you want the federal government enforcing? I dare say FCPA is not going to come out of anybody's mouth. They're not going to know about the law. And if they do, it would be nowhere near the top 10 list. So why do I say that? When you see the hysterical reactions of what does this mean for enforcement, I don't think it's fair to say that a right sizing from a position of 14, 15 prosecutors 10 years ago that went upwards of 40, 45 most recently, going back to what maybe were more traditional standards is not necessarily a sky is falling event. And I do think it's more responsive to the desires of the American taxpayers. Now, as we'll discuss in a moment, DOJ also just issued important new guidance coming out on May 12th, a series of memoranda on white collar enforcement. And so this discussion is actually quite timely. We're going to dig into those guidance memos and the new approach to white collar enforcement generally and the FCPA specifically. And I think it'll be important for everybody here, especially those who represent companies in this space. But Brian, I'd love to hear your thoughts as well as we get into this.
Yeah, sure. Thank you, Fry. And just a few kind of opening remarks before we, dive into some back and forth on some questions that Fry and I have been kicking around as we got ready for today's discussion. Fry mentions, what he calls hysteria. I think what some have called, real shock and surprise about the second Trump administration's at least initial approach to white collar enforcement and the FCPA. Generally, I think a lot of that is born out of the fact that during the first Trump administration, from 2017 to 2021, the track record of the Department of Justice and the SEC when it came to FCPA enforcement was actually quite robust. There was fairly strong enforcement by both agencies. A number of landmark cases were brought, and a number of kind of important policy reforms were implemented. And we'll discuss those, today. And when you kind of compare that against the Biden administration's FCPA track record, I think the latter looks surprisingly less robust. There were fewer significant cases, smaller resolutions, decidedly less comprehensive changes to some of the relevant policies. So, we find ourselves in the very early days of the Trump administration, the second Trump administration. And, like the rest of government, I think the Department of Justice is really undergoing a fundamental reorientation in this administration and with this leadership. And corporate criminal enforcement and the FCPA is really no exception. And we'll talk a little bit about some of those changes as we move through the presentation today. Now, I do want to just at the outset answer a former Attorney General Holder's question. No, bribery is not legal. Despite changes, as we'll talk about, significant changes, anti-corruption risks do remain. And I think both Fry and I expect FCPA enforcement to emerge different from the end of this process, but still significant. And there'll be more focus on things like national security and competitiveness, but certainly still a enforcement program at the DOJ. The bottom line is that companies really can't let up. Statutes of limitations are longer than presidential terms. There are authorities overseas that have really stepped up their enforcement of anti-corruption in recent years, and those risks remain for companies, and we'll unpack all of that today.
Yeah, it's a really good point. I know we're going to dig into that as well. One of the things, Brian, I want to dig into, you played a really significant role in the first Trump administration. As you said, you were first in the White House counsel's office. You were at the SEC, you were senior policy advisor to then Chairman Clayton. You were also chief of staff to Attorney General Barr and then head of the criminal division. Now, President Trump had been critical of the FCPA for several years before he became president in 2017. Most notably calling the law a terrible law on a CNBC interview back in 2012. And I will say, as someone who was within the unit working those cases, many were surprised to actually see such robust international corruption enforcement during his first term. Why do you think that was?
It's an interesting question, Fry, that I think a lot of folks are asking, given, as I mentioned a minute ago, some of the changes that appear to be in store for the FCPA in the second Trump administration. What I'll say is that the Department of Justice and the SEC during the first Trump administration largely tried to pursue what I've described as a common sense FCPA enforcement program. And what do I mean by that? I mean that we didn't shy away from major cases when it was appropriate to bring them. And if you look at the department and the SEC's track record in the first Trump administration, there are a number of landmark cases. One MDB, which was by some measure the largest FCPA resolution in history, Airbus, JNF, Ericsson, Petrobras. There are a whole list of very significant FCPA cases that were brought. But when we brought those cases, we tried to ensure that we took a reasonable approach, in terms of the use of monitors, which was something that, has been controversial over the years. We really ensured that they were only used in limited circumstances when absolutely appropriate. They were something that I personally was very skeptical of. We were willing to use kind of alternative forms of resolution like DPAs and NPAs when appropriate. And we didn't insist on guilty pleas from corporate defendants except in limited cases. We tried not to overly punish companies with excessive penalties, recognizing that shareholders of those companies were often the ultimate payers of those penalties. We sought to provide appropriate offsets and credits for parallel resolutions with civil authorities and foreign partners when it was appropriate to do so. And we really focused a lot on individual accountability, recognizing that the executives and the corporate employees who were responsible for the conduct were really the true culpable actors in a lot of the bribery schemes that we identified. And we also tried to ensure that our internal policies and what we were telling the public aligned with that approach. We developed the corporate enforcement program first in the context of FCPA resolutions and later expanded it to all resolutions in the corporate context in the criminal division. We sought to provide really clear guidance about our expectations and the incentives that we provided to companies for coming forward and self-disclosing and cooperating. And we tried to provide process to encourage companies to come forward and ensure that there would be at least some predictability in the process once they did make a self-disclosure to DOJ. And we published a lot of this. We talked about it in speeches. And we published guidance on things like the evaluation of corporate compliance programs and how those fit into the resolution analysis for us, and how we would and when we would select monitors. Again, to be clear with the public and with corporations about what our expectations were, and more importantly, what they could expect when they came to deal with and sat across the table from DOJ. One of the other key factors I think that was really important to the success of the program in the first Trump administration was the support from leadership at DOJ and the SEC across 2 attorneys general, and at the SEC across 1 chairman. There was no expectation that there would need to be blockbuster resolutions. There was a mandate to pursue fair resolutions that recognize the facts and that were appropriate under the circumstances. And there really wasn't micromanagement where political leadership at the department was reaching down into cases and dictating particular results. Again, there was a kind of a mandate to be fair and to arrive at the right result. But line prosecutors like yourself and their supervisors were largely left to negotiate the terms of resolutions to the extent that they could and pursue what they thought was the best result under the circumstances, again, with appropriate supervision. So actually, Fry, I'd like to get your perspective on it as well. You, as you mentioned, were a supervisor in DOJ's FCPA unit during the first Trump administration, although we didn't overlap when I was there. Given your perspective, which again was a lot closer to the actual day-to-day running of some of these cases, what's your impression of the enforcement program during the first Trump administration, and why we saw what I would describe as a fairly robust enforcement program?
Yeah, it's true. And I mean, I touched on this earlier. The overwhelming thought at the time of Trump's election in 2016 was, well, you will definitely see a dip in FCPA enforcement. I mean, I would say there was some murmurs within the unit of, the FCPA unit being dissolved. Is it going to even exist anymore, given some of President Trump's previous comments? From my perspective, having worked a number of different types of cases, you do what you're asked to do. I happen to have been in that unit, so those were the cases we were working. But it is interesting, if you were to actually look at the historic graphs, there's a huge uptick at the end of 2016 from November 16 through January 17 in enforcement cases. Why was that? Well, then Fraud Section Chief Andrew Weissman, you may remember his name, actually put together what appears to have been, in retrospect, quite a fire sale of FCPA cases, very much because he thought that there may no longer be an FCPA enforcement regime. But of course, the opposite was the case. And if you actually look, as you said, over the next several years, the approach that was taken actually led to very robust enforcement. And year after year, that enforcement kind of broke new records. And I think I give that a few reasons. I have a few reasons, I think, for that. One is what you just touched on. It was not a priority. And when it's not a priority, that means you have less cooks in the kitchen. You have less people in senior management who feel a need to influence every single decision being made in a large corporate investigation. Contrast that, as you mentioned, to the Biden administration's approach, where they really elevated in the early days FCPA to being this national security priority. And yet we do see and did see less enforcement actions as a result. And I think part of that was the paralysis or stagnation in trying to get too much influence and oversight involved in every step of the way from senior management. So cases were not allowed to work, to be worked and to move, just following the evidence that they were in the first Trump administration. I think there was a lot of momentum also in the space. There were a lot of efforts to establish ties with foreign authorities. In 2014 and in 18, there were training sessions that DOJ and the SEC hosted for foreign countries. I think the one in 18 had about 45 countries send over 200 prosecutors to DC. The reason was the idea was to train up on enforcement, where given international cases, you need that cooperation. But in reality, it was to develop informal ties and information sharing. So that was something that lent itself to closer coordination on these types of cases. And as I said earlier, the shift in resources going from 15 to over 30 prosecutors in that 5-year time frame. Obviously that will lead to more and more cases being brought. But I think another piece of this is you're saying the common sense approach to prosecutions, that's right. And the first thing was to go after individuals. And if the individuals had broken the law, that made it a lot harder when you're flipping an individual who becomes a cooperator against the company that person worked for that company to then evade a settlement. And previously, really the approach, oftentimes it was difficult to bring cases against companies if you don't have any individuals you can prove that crime was committed. So that fundamental shift, which I do think was a common sense approach to white collar enforcement, actually paid dividends in terms of the kind of cases that were brought. And then you mentioned also the crediting and offsets that were in place. That was significant. There was a decision made internally, and I want to touch on this a little bit later as we talk. The credits were significant for a lot of these countries. It was the very first time maybe they had a corporate case, and yet they were able to keep 50, sometimes 80, 90% of the total fines by the companies. And that obviously would be a huge incentive for them to cooperate moving forward. And I think that also paid dividends. And I guess finally was a lot of these cases came out of Brazil, where they had a very big enforcement regime, a real effort by their prosecutors down there to go after what was a huge corruption scandal with the Operation Car Wash cases. And so I think that also fed a good deal of this enforcement activity. Now, Brian, I want to maybe just turn our attention now to the new policy memos that came out. On May 12th, Assistant Attorney General Matthew Gagliotti released 4 memos detailing the Trump administration's new approach to white-collar crime. And specifically, perhaps the most significant one of the memos was the white-collar enforcement memo entitled Focus, Fairness, and Efficiency in the Fight Against White-Collar Crime. And it articulated a new approach aimed at fighting waste, fraud, and abuse, healthcare, tariff and customs evasion, investment fraud cases, elder abuse, these types of cases, material support for terrorism. And notably, I was at least surprised that FCPA and money laundering cases came in at number 9 in that top 10 list of priorities. There were some corollary memos, one talking about monitorships that I will discuss, and one talking about the whistleblower program that was also updated. But I think I was generally thinking, would this be a revolutionary shift? And Brian, I want to get your perspective. What did you think? What was your reaction to the DOJ guidance?
It's a good question, Fry. Just to circle back for a second, just to add to one point, about the foreign cooperation. One of the other key things we did was actually embed a prosecutor from the criminal division in the SFO over in the United Kingdom. So again, just another example of, the really significant cooperation and intertwining of both domestic and foreign authorities. But going back to the DOJ guidance memos that you just mentioned, I was actually surprised with how similar they were to some of the prior memos that we've seen, both from my tenure and from the Biden administration. They're, to be clear, really significant differences. There's a flowchart, for example, which I think is the first time I've ever seen a flowchart in a criminal division guidance document that kind of describes how you get from self-disclosure to a declination, kind of a choose your own adventure flowchart, which some may find very helpful. But generally speaking, since the election and since President Trump was inaugurated for a second time, there's really been this talk of kind of a sea change or a seismic shift in white collar criminal enforcement at the Department of Justice. And I think a lot of people expected whatever came out of the criminal division's revisions to these policies and to its approach to white collar crime to really be fundamental and significant. And again, there are significant changes, but at least in terms of the framework that the criminal division seems to be employing here, very similar to prior memos. I actually, as you think about it, it really isn't all that surprising, given, as I mentioned earlier, a lot of the common sense reforms that were implemented during the first Trump administration. So in some sense, it's a return to and a further building out on those. But I think that the takeaway from these memos, at least as I see it, is that white collar enforcement is going to be different under the second Trump administration. In some cases, different in a better way, but it's still going to remain something that the department does and that the department devotes resources to. Otherwise, why would they take the time to prepare and to issue these memos? In terms of specifics, I was really surprised to see the criminal division's whistleblower program not only survive, but actually be something that was embraced by the new DOJ leadership. Unlike the SEC and the CFTC's whistleblower programs, which have a grounding in Dodd-Frank and a statutory basis, there really isn't a statutory basis for the criminal division whistleblower program. That's something that was created by the Biden DOJ leadership, I thought, to try to piggyback on the success of the SEC and the CFTC program in terms of encouraging and incenting disclosures. I've been predicting since the election that the criminal division's whistleblower program wouldn't survive, but I was wrong. And it's been reoriented, and we'll talk a little bit about that. But it's there, and it's something that at least the new Trump DOJ is going to continue to rely on to generate tips for investigations. That plus the continued incentives that the corporate enforcement program continues to provide for self-disclosures, I think really highlights how much DOJ does rely on tips from whistleblowers and self-disclosures to make their cases. I think one of the other takeaways I had was, that the policies still leave a really significant amount of discretion in the hands of prosecutors. We'll talk a little bit about, where those discretion points are. But I think if you ask anybody that practices in our space, one of the principal impediments or kind of things that discourage people from approaching DOJ to self-report, to cooperate, is the amount of discretion that's left in the hands of DOJ. and the fact that they have a lot of play in the joints of the prior policies. And that really does remain with these new policies. For example, the prior policy, if you checked all the boxes, if you self-reported, if you fully cooperated, if you completely remediated, you got a presumption of a declination. Well, now that says that there'll be a declination. So they've struck the word presumption. I'm not really sure what the difference is. Again, there's a lot of discretion built in along the way in terms of what constitutes adequate self-reporting, what constitutes full cooperation and full remediation. I think those are going to remain gray areas that are going to be risk areas for corporations thinking about coming forward to DOJ. Really the biggest takeaway, for me, were the priorities that the memo announced, both what was added to those, and we'll talk a little bit about that. But again, it echoes what Attorney General Bondi laid out in her February memo, which you mentioned at the outset, which is a focus on TCOs, cartels, offenses of that nature, but also what was retained, right? I mean, again, we're here today talking about the FCPA and whether, reports of its demise have been greatly exaggerated. The FCPA remains a priority that was listed in the May 12th memo that we saw from the head of the criminal division, which I think surprised many. It didn't really surprise me, but it shows me that the FCPA at least is going to be something that's enforced going forward by DOJ. But how about you? What's your take on the May 12th memo, Fry, and what were your principal takeaways from it?
Yeah, I mean, I couldn't agree more, 100%. I mean, number one, you touched on the whistleblower program. I was a little critical when it first came out because there are differences in the SEC whistleblower program and what the SEC can do in the civil enforcement context versus the real concerns that arise from a prosecutor's perspective with whistleblowers, Giglio and Brady concerns that possibly come up in that context that don't exist and that exist in the criminal context that don't exist in the civil context. And if I were a supervisor or leading the department, that would be an area what I really, like you said, would have expected maybe them to abandon that program in criminal context. And instead, actually, it was reshaped. And among other things, as you mentioned, FCPA is the number 2 area for whistleblowers now when they're listing the kind of priority cases they want whistleblowers to come forward in. Interestingly, corruption and international corruption cases was number 2 on that list. So again, as you said, you're discounting any suggestion that FCPA is dead. In fact, it's very much alive, although it's just not going to be as high a priority as it had been in the past. The other, I think, big takeaways, I was truly, given everything we'd seen a number of cases where FCPA cases had been terminated, DPAs terminated early in the last several months, monitorships had been terminated early. There was a real feeling that, okay, well, white collar enforcement very well might be curtailed significantly moving forward. Investigations, Stryker, Petronor, Bombardier all announced that those investigations had been closed in the last few months. So I was actually quite surprised that it wasn't as revolutionary a change in a lot of these memos. And it does very much look like you said, it kind of fighting things at the margins. Here is the very helpful flow chart, as you said.
There it is. There it is.
And, but that leaves, like you said, there's a lot of discretion still. What does it mean to fully cooperate or to timely remediate? I mean, the fact that we still have aggravating circumstances that might dictate if they exist and whether or not you'll get a declination or a DPA for a company, you've got to still fight every one of those fights if you go in and talk to DOJ in a self-reporting context. And I frankly don't think this moves the needle all that much for companies trying to make that decision. Very much, this discretion that's retained, I think, makes it a very, very hard hurdle for anybody to decide I'm going to go walk into the government and hope in a few years that I get a declination. I don't think it really moves the needle that much at all. So I was surprised by that. But again, I think the big picture takeaway is white collar enforcement is going to continue. Might be a little more focused. In fact, that's the name of the memo. But it's certainly not any sea change whatsoever. The monitorship piece as well, the memo on the monitorship, it is not self-evident by any stretch that corporate monitorships should even exist, right? This is a creation of the department to try to deal with companies that have real compliance problems. And yet the monitor memo, describes monitors as an effective resource, quote unquote. I was actually kind of surprised to see that, even though there is a good suggestion in there that they will be used more sparingly in the future. I think we should expect that. But I was just surprised that frankly, it retained the monitors as a measure at all that can be imposed in connection with any corporate resolution. I'd say the one good thing I saw in that memo was the focus on budget and cost, and that those will actually need to be articulated in resolutions moving forward in the paperwork. That's really significant because the issue with monitors, in addition to the intrusive nature that they have on a company and the ongoing operations, the scope creep is a real problem, and nobody is able to really effectively mind cost and budget overruns. Companies, they're disincentivized to go back to the monitor. It will determine whether or not they're clear and certified by saying, wait a minute, aren't you looking into the wrong things? Or isn't this costing too much money? It's a very difficult conversation to have. So having that articulated in the paperwork, I think will be useful. And hopefully that's something that, to the extent there are monitors moving forward, the DOJ sticks to that. So, I mean, those are my immediate takeaways, at a big picture level. Obviously, we could talk for hours on each of these, but I was just really surprised. I think, in many ways, we're going to see some more business as usual, but maybe just focused on some different types of priorities.
I think you make a really good point about the monitors, Fry. I mean, we've seen even in the early days of the second Trump administration, the department moving to terminate monitorships early, right? Or to revisit the terms of monitorships and their scope, and to see kind of an acknowledgement, at least on paper, that monitors would continue to be a tool, really struck me as significant. And I wonder whether, that is intended to kind of preserve them as a tool for some of the other investigations that DOJ is doing, maybe outside of the criminal division. Like we're really focused here on discussion about the FCPA, and discussion of anti-corruption enforcement. But as you know, the department has announced a whole host of new initiatives in the education space, in the employment space, a lot coming out of the civil rights division over the last several months that's new and that's different in terms of their orientation and priorities. And I wonder whether, the kind of hook for continued use of monitors by the department is intended to provide a tool for cases like that to maybe impose monitorships on institutions. I don't know. I'm just, I was also surprised to see it there.
Yeah, well, I mean, your lips to God's ears, because that actually, if there is possibly a good use of monitorships, putting them on some of those educational institutions, that would align pretty well with some of the Trump initiatives we've seen from our administration. That makes sense. Actually, I hadn't thought about that before. But Brian, kind of back to the FCPA, one of the interesting things I noticed was the memo, the May 12th memo that AAG Galeotti put out has a footnote 6 on page 4 when it talks about the FCPA as among the top 10 priorities, which cites back to President Trump's February 10th executive order. And I've heard now some people say, well, is this the guidance now that the Attorney General was directed to put forth after the 180-day pause? I, for one, had been expecting some concrete guidance coming out in August, September about what is the new DOJ going to be doing with the FCPA. But what do you think? Is that it, or should we be expecting some more guidance moving forward?
Fry, I'm not convinced that is it. I don't know that the May 12th memos represent the department's last word on the FCPA, and the revisions and the changes that everyone is expecting per the EO. The EO was very clear in directing the AG to undertake, what I think could be characterized as a fairly fundamental rethink of the DOJ's approach to the FCPA. It would be really strange to bury the department's response to that in, a footnote in a memorandum coming out of the criminal division. And the executive order raises questions that the memo doesn't answer. For example, the EO says that the AG must authorize all FCPA actions after the new guidelines are issued. I don't think that the May 12th memo really squarely addresses how that might happen. So I think we're going to see more and probably more comprehensive guidance about how the DOJ will approach FCPA and FCPA investigations and resolutions going forward. The May 12th memo is going to be relevant to that, but I don't think it's the last that we've heard from DOJ on this. I think, reasonably something later this summer would be what I would look to. Again, I don't know. I don't know about any of this. This is all predictive and speculative on my part, but that would be my guess.
Yeah, I tend to agree with you on that. And what interestingly, the way it's described on the list of priorities, it's bribery and associated money laundering that impact U.S. national security interests, and it undermines U.S. national security and harms competitiveness of U.S. businesses, enriches foreign officials. That's the language, and that's not also limited to the cartels or transnational criminal organizations. So if you're reading any tea leaves there, I think it's broader than perhaps Attorney General Bondi's initial memo, February 5th is, but I tend to agree with you. I expect we'll see quite a bit more guidance on this to directly respond to the executive order.
Yeah, agreed. I agree. So far, look, we've been talking a lot about process, right? This is a lot of inside baseball for lawyers like us, but the EO specifically directs the AG to also issue updated guidelines and policies about the FCPA that promote the president's Article 2 authority to conduct foreign affairs and prioritizes American interests, American economic competitiveness with respect to other nations, and efficient use of federal law enforcement resources. To me, putting kind of procedure aside for a second, that sounds a lot like substantive changes to the types of FCPA cases that we're going to see the DOJ pursuing. And it sounds, frankly, a lot like what some might call an America First approach to the FCPA, which I think is, if I'm not mistaken, the title of our talk today. So let me ask you, because I want to hear what you have to say first. What does that actually mean? What can we expect to see in practice with an America First approach to the FCPA?
Well, look, when I saw the EO first come out, I actually ended up penning an op-ed on this. It was in the Hill, and it kind of really went through some specific recommendations, because this would be a sea change in how the Department of Justice enforces, and the SEC would enforce the FCPA. And as you said, the EO asks DOJ to really put out guidance on how, number one, the law can be used specifically to advance the interests of U.S. companies. And also just the business community at large, but really the American business community. And I think first you take a step back. What people may not appreciate is that over 50% of all FCPA cases right now are against foreign companies. Historically, that has been the case. 9 of the 10 largest FCPA enforcement actions have been against foreign companies, and so in many ways this has been combating foreign companies were not playing by the rules. And, that I think is a result of the fact that the FCPA has been the oldest law in the books. I mean, up until 15, 20 years ago, it was perfectly legal to bribe foreign officials in Germany, for example, and you could write it off on your taxes. So it is a very different business climate. And one of the things in light of all the enforcement activity against foreign companies, I recall, when I was at DOJ and I'd speak to foreign audiences, oftentimes, I would be asked, and in fact, more likely targeted for criticized, saying that isn't the US government using the FCPA to advance American foreign policy? And the reality is no, that was definitely not the case. But actually, I thought to myself, why isn't it? Why isn't the FCPA part of a more strategic, tool of the broader toolkit to advance U.S. policies? So I think there is a real opportunity here for the Trump administration to issue guidance, for the Attorney General Bondi to come out with guidance that does just that. So some of the things I talked about in the op-ed, and I'll kind of revisit now. I think the opportunities for change. One, changing the shift from the supply side to the demand side of bribery. From the inception of the law, it was always focused on the supply side. In fact, it wasn't even illegal. You could not prosecute foreign officials for soliciting bribes. It was only for the paying of bribes. Historically, DOJ got around that by bringing money laundering cases or wire fraud charges, but it was not explicitly prohibited to demand or solicit a bribe from a US company or individual. Now that has been changed in 2023 with the Foreign Extortion Prevention Act. And so now that gap in the law has actually been changed. And the reality is there's an opportunity here to build on that. Over the last several years, cooperation, as DOJ defined it, was really focused on how does a company help the government prosecute corporate executives? That was the priority. So let's change that. Moving forward, the Trump administration could shift that to the corrupt foreign officials. Focus on the demand side of bribery, and actually not only would US companies benefit, but all companies would benefit as a result. And you would actually then create real incentives for companies to come in and cooperate. I would say, one other opportunity here, we look at the changes to the corporate enforcement policy, Brian, and just the, some of the things at the margins, which I said a moment ago, really, I don't think that moves the needle for companies to cooperate. But if you want to talk about in the FCPA context, maybe you start with US companies or make it open to all companies. Self-report an FCPA case, help DOJ cooperate against the corrupt official. And in return, DOJ promises you an MPA, non-prosecution agreement, and do that within days, not within years. The current regime, the problem is companies, when they come into the government, they are biting themselves off a multi-year investigation, and they can only hope at the end of the day that maybe they get a declination, but they still have to pay a disgorgement of profits and potentially a fine as well. And that could be tens, hundreds of millions of dollars, billions of dollars. So change that, right? Give the opportunity for companies to come in, report a bribery case, and help the government cooperate against the foreign official. Why? And if you can get an MPA then within days, which can always be torn up if the company ends up breaching that and doesn't fully cooperate, but you have some finality and some resolution, and you can actually move the needle in helping to build cases against the foreign officials. And I think one key here is the MPA here is a critical component, not a declination. And why is that? What we talked about earlier about the statute of limitations period on these cases, they go back, 5, 6 years on FCPA cases, 10 years on money laundering cases. You get up to 3 years for foreign evidence collection. These cases are going to span multiple administrations. In the way things have been working lately, whatever next administration comes in, they're just going to do a 180-degree different turn on what the last one did. And if that happens to be a Democrat administration, you can see enforcement of the FCPA being front and center and focusing on companies that may have received the declination, for example. If I'm representing a company, I don't want that. I want an MPA that doesn't require disgorgement, doesn't require a fine. And my consideration is helping you build the case against the corrupt official. And then that company can actually use that as a shield against future administrations, against foreign authorities. That would be a real shift, a real change in FCPA enforcement, and that would be meaningful change. So if that's something that if the current administration wants stickiness and wants change, that is something that would actually be a sea change in FCPA enforcement, and also would help avoid fines on US taxpayers, on shareholders for the companies. That's one. I think another one is, using the FCPA as a geopolitical lever. Right now, we've talked a ton, not today, but the media has been talking a great deal about the tariff regimes, sanctions. FCPA can be another tool in that toolkit to use against foreign countries that are not playing ball in other respects. And so, give you an example, if you have the fentanyl problem with drugs coming into our southern border with Mexico and being manufactured in China. If those countries aren't playing ball, you tell those countries, well, anyone operating in those countries are now going to get closer scrutiny for FCPA violations as well. You receive subpoenas. Companies are going to then use that pressure on the government leaders, hopefully get them to play ball in connection with these other political objectives of the administration. So that's another area. And then, conversely, if you are cooperating, then activity in that country becomes a lower priority among all the countries that could be investigated in the FCPA space. So that's another actual concrete real measure that could be taken that is a little bit more strategically aimed. We talked about fines and the offsetting and crediting of fines. I mentioned earlier, the routine has been 50 to 90% of the fines end up going to foreign countries. So Odebrecht, Petrobras, Brazil kept 80 to 90% of those fines. You know, the UK kept 75% in Rolls-Royce. You can go on and on. DOJ and the SEC typically do the lion's share of the work in these cases. But the government has not been keeping the majority of the fine payments there. So that's another thing that maybe at the margins could be a change in how the enforcement regime works, and could, you know, arguably reward US taxpayers in a more fair way. And not to mention the fact that these foreign countries actually have an obligation to cooperate with the US, given all of the various multinational treaty obligations that they've got. Now, I'll say the last point on this is the criticism has been that if DOJ takes any of these measures, or the government takes any of these measures, we're going to be violating the OECD Convention Against Foreign Bribery. And I actually think that's probably right. The OECD was passed in the late 90s, and it prohibits the use of foreign bribery laws to advance a member state's political interests or domestic companies specifically. And that's Section 5 of the OECD Convention. The reality is, though, that DOJ and the SEC have spent American resources and handled up to 75% of all foreign bribery cases over the last several decades. So the argument would be that, you know, US companies should be the first to benefit from all of the resources that America puts into these cases. And if that means you need to renegotiate that treaty, I would say if there's ever an administration that's probably willing to renegotiate or withdraw from a treaty, it's probably this one. So I don't think you can square that circle on the OECD piece of this, but I don't think also that that's going to necessarily impact how the Trump administration's DOJ moves forward. So here's a handful of ideas that I think could actually lead to some meaningful change. Now,
Good.
do any of them? I don't know, but just some suggestions.
Good points, Fry. It's almost like you'd written them down somewhere and then published them. Look, I think, you know, Fry really said it all on that point. You know, for my part, I think the EO is very clear in directing that the focus be on American competitiveness, you know, and a perception, right or wrong, that the FCPA puts American companies at a disadvantage when doing business abroad. And so you can see that sentiment in the EO, you know, kind of a perception that the FCPA unduly interferes with the president's Article 2 power over foreign affairs. I mean, those that have really never worked at the department, you know, I think would be surprised at the extent to which foreign affairs issues can factor into decision making in cases that have, you know, significant international elements. You know, and I think there seems to be a perception among the leadership in the new administration that the FCPA, and in particular FIPA, which you mentioned, with the criminalization of demand side of bribery, you know, are blunt instruments that could potentially interfere with the president's ability to conduct foreign affairs, you know, per Article 2. So, you know, where an America First enforcement approach to the FCPA lands, I think remains to be seen, but it's certainly going to reflect those considerations, you know, that the president laid out in the EO.
Hey,
I think, go ahead, Frank.
No, sorry. Just wanted to ask you real quick. The EO is really directed at DOJ. It doesn't really talk about the SEC. But I think, you know, given your past experience with the SEC, the fact you knew former Chairman Clayton well, you know him well, you know, Chairman Atkins well. I mean, what are your thoughts on how the SEC would react to all of this?
That's a good question, Fry. We've been talking almost exclusively about DOJ. You know, right up front, the current acting deputy director, I believe, has said that the SEC will follow DOJ's lead when it comes to the FCPA. I think that's largely been true so far. But that was also a preliminary statement that was made during, you know, kind of the transitionary period at the SEC before Chairman Atkins, you know, got in the seat. I think the question is, will it continue now that he's there? And once he gets his permanent leadership in place in the enforcement division, I think it probably will, and I think it probably should. You know, this administration has signaled that it intends to exert, you know, much more control and alignment over so-called independent agencies. It's issued, you know, an executive order bringing commissions and their rulemaking processes into alignment with the White House. It's challenged Humphrey's executor and the courts. It clearly expects alignment, especially on core executive functions like enforcement of the laws. You know, I think formally or informally, you can expect the SEC's enforcement of the FCPA to broadly align with the administration's approach and the priorities. What exactly that'll look like remains to be seen. I think it'll depend a little bit on where DOJ comes out. But I think the priorities that are outlined in the May 12 memo, and in any forthcoming guidance about the FCPA are going to be good guides. And as I alluded to earlier, I think that's really the way it should be, Fry. I mean, again, the president has the constitutional duty to take care that the laws are faithfully executed. It would be very strange to me to have an agency carrying out a core executive function like law enforcement in a way that isn't at least in broad harmony with the way the president has directed it to be carried out. Now, again, that doesn't mean the president's making decisions in individual cases, but again, in terms of policies and priorities and focus, I think we can expect, and there probably should be, broad alignment between DOJ and the FCC.
Yeah, makes sense. Well, it looks like we have only a few minutes left, and we do have a couple of questions. Maybe the first, I don't know, Caroline, do you want to?
Absolutely. Yeah. So one question we got from an audience member is, how will the changes affect your advice to clients about coming forward to the DOJ or SEC about regarding disclosures about a matter?
You would take that one, Frank?
You want me to go ahead?
Look, I'll say what I said at the beginning, and I'll just keep this short because I know we've got a number of questions to work through. My advice to clients kind of prospectively is, as I said, the statute of limitations on the FCPA is longer than a presidential term. The FCPA remains on the books. Should companies kind of reweight their risk considerations when looking at their compliance programs and screening for violations and that sort of thing? Yeah, absolutely. Right. I mean, they should add the new priorities that come from the DOJ guidance we've seen, and they should reweight corruption risk and the FCPA, but it's not open season on bribery of foreign officials.
Yeah, I think there are two main takeaways that I'm talking to my clients about from all this so far. And the first one is, if you have a company that is operating under a DPA right now, or an NPA, or in a monitorship, you could not. I mean, now is the time to engage with the department and try to see if you can get an early termination. We've seen it already happening. The new guidance memos specifically say they're going to be reviewing the ongoing enforcement actions, for that very reason. So that's a very easy one. I think it's clear, and frankly, be malpractice not to revisit that and try to engage. I'm helping a client right now in that very situation, because I think the door is wide open for people to try to take advantage of that. We've talked a bit already. I think this question specifically goes to self-reports. And again, I think right now, I don't think the needle has changed on self-reporting and that calculus, but I'm hopeful, at least as it relates to future FCPA guidance, that they really do open the door for that, because there's real opportunities, as I already talked about. But the real interesting thing is, and Brian just touched on this, the memo and the enforcement priorities does set forth a blueprint for compliance counsel to understand, okay, let's do a new risk assessment. Where are our risks now in light of the shifting priorities within the department? If we thought they were previously FCPA, are they, is that as big a risk? Or, for example, am I operating in Mexico in areas that might have touch points with cartels? Am I operating in a financial institution that does a lot of transactions with China, and that covers a number of transactions with China or Latin America that could be, have a nexus to some of these AML concerns that we know are a higher priority right now for the department? So I think doing that risk assessment, trying to appreciate, are there new risks now that you have to deal with, is going to be essential. And DOJ's thankfully made it quite easy for you to appreciate how they're thinking about the laws that they want to enforce, and you got to make sure now that you're towing the line in that respect. So that may be the only question we cover, but hopefully that's helpful.
Yes, no, thank you both so much for your time. And on behalf of the Federalist Society, I want to thank you for joining us today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in. And with that, we are adjourned.